Good afternoon, everyone in Southeast Asia. Good morning and good evening to all of you around the globe who are tuned in today. Welcome and hello from Manila. My name is Rocky Guzman. I am the Deputy Director of the Asian Research Institute for Environmental Law, or ARIEL, and I am honored to be the moderator for today's special webinar, which will be the launch of the UNEP Working Paper on Environmental Rule of Law and Human Rights in Asia Pacific, with a particular focus on supporting the protection of environmental human rights defenders, or EHRDs. Now, today we focus on a very important topic in Asia Pacific, the status and ways forward in terms of environmental rule of law and human rights in the region. In this launch, we give a snapshot of the UNEP Working Paper, which presents trends in the region for the application of both environmental law and human rights. Today will also remind us that the realization of human rights and environmental rule of law are necessary for the achievement of the Sustainable Development Goals. But first, some context. We have to remember that human rights and the environment are intertwined, and sustainable environmental governance cannot exist without a safe, clean, healthy, and sustainable environment. Central to this discussion is the vital role of environmental and human rights defenders, EHRDs. You'll hear more of this in this session, in ensuring the protection of our natural resources. However, states and society have sometimes failed to afford EHRDs due protection, and they are increasingly faced with danger for doing their work. The fact is, according to a 2021 report from Frontline Defenders, at least 331 defenders were killed for carrying out human rights work in 2021. In 2020, with 70% of that number working on environment and indigenous people's rights. In the more recent Global Witness report, 2022 recorded 200 murders of land and environment defenders, with over 30 of this number in Asia Pacific. Now, this working paper summarizes legal and policy issues that must be addressed concerning threats to environmental and human rights defenders. We'll discuss the status, issues, and challenges, and through this platform, we hope to suggest ways forward to address these gaps. Through our speakers, we hope to get a clearer picture of what's happening and what we can do to uphold a robust environmental rule of law in the region. Now, I know many people are keen to know more about this topic, so we'll put also the link of the working paper in the chat box, so please check that out. Okay, before we start, we'd like to acknowledge the organizers of this event, the United Nations Environment Program, or UNEP, the Asia Pacific Network for Environment Defenders, or APNED, and of course, ARIEL. This event is also supported by Law Asia and the National Environmental Law Association. We thank our esteemed panelists today for their insights and expertise. And please note, everyone, that after this session, we'll have a Q&A, although you can ask your questions at any time through the question box below in your screen. Please be informed that we're also live at Facebook and LinkedIn through the ARIEL page. Okay, now before anything else, I am honored to introduce a special guest who will be opening this launch event. We have none other than Patricia Kameri Mbote. Patricia is the director of the Law Division of UNEP, joining us from Nairobi, Kenya. She has in-depth experience in environmental law acquired at local, national, regional, and international levels, and has been a professor of law at the University of Nairobi, where she has taught for over 30 years and served as dean. Patricia, we are honored to have you, and please, you have the floor.
Thank you very much. Good afternoon, good morning, good evening, depending on where you're linking up from. I'd like to thank ARIEL and the organizers for this special event, and especially the launch of the working paper on environmental rule of law and human rights in Asia Pacific, focusing specifically on support for protection of environmental human rights defenders. We should remember that the General Assembly passed a resolution on the 28th of July 2022, declaring that a healthy environment is a human right. Colleagues and friends, right now we need to accelerate action on Sustainable Development Goal 16, which provides a framework for peace, justice for all, and strong institutions. This is fundamental to accelerating progress of all other sustainable development goals. Promoting the rule of law through the SDG target 16.3 is critical to ensuring the achievement of fundamental freedoms, of access to information, guarantees of civic space, and free, independent, plural, and diverse media. It also assists in building and supporting public participation, inclusive and peaceful societies, and in holding public institutions and officials responsible for their actions. However, according to several indicators, people and communities are in fact being left behind. Civic space is continuing to shrink globally as well as in the Asia-Pacific region. Colleagues and friends, since 2012, UNEP has developed the concept of environmental rule of law as part of its normative agenda. It is understood as the legal framework of substantive and procedural rights and obligations that incorporates the principles of ecologically sustainable development in the rule of law. Environmental rule of law is key to addressing the full range of environmental challenges, including climate change, biodiversity loss, water scarcity, air and water pollution, and soil degradation. Driven by the urgency of the triple planetary crisis, the push for environmental rule of law has gone from obscurity to ubiquity. It has become increasingly apparent that failure to implement and enforce environmental law directly threatens environmental progress and sustainability. But colleagues and friends, implementing environmental rule of law is not simply about bringing violators to justice. While enforcing existing laws is critical, the goal of the environmental rule of law is to change behavior onto a course towards sustainability by creating an expectation of compliance with environmental law and by coordinating between government, industry, and civil society. Also, by leaving no one behind. Environmental rule of law provides the foundation for good environmental governance and the realization of the right to a healthy environment for all. How is environmental rule of law a foundation for the right to a healthy environment? Well, just as fundamental rights cannot be enjoyed without a healthy environment, a state where the environmental rule of law is upheld cannot exist without the establishment of and respect for rights. It is with these remarks that I draw your attention to environmental human rights defenders who are the focus of the report that will be launched, who defend community, substantive, environmental, land, water, and subsistence rights, and advocate for sustainable development. The United Nations describes environmental human rights defenders as individuals and groups who, in their personal or professional capacity and in a peaceful manner, strive to protect and promote human rights relating to the environment. Through their actions, environmental human rights defenders play an important role in upholding and advancing the environmental rule of law. Environmental human rights defenders often protect substantive rights through procedural access rights to public participation, access to justice, and information. However, as the experts and authors of this report will point out today, environmental rule of law and procedural environmental rights are unfortunately increasingly threatened across the Asia-Pacific region. In fact, Asia-Pacific was the most dangerous region for environmental human rights defenders in business-related attacks in 2021. Because of their environmental and social advocacy, environmental human rights defenders have been subject to increasing threats and physical violence. And worldwide, especially in the resource-rich countries, murders of defenders have been increasing. And this is highlighted in different reports, including the 2022 Global Witness reports. Colleagues and friends, in 2019, the United Nations Human Rights Council unanimously adopted a strong consensus resolution recognizing the contribution of environmental human rights defenders to the enjoyment of human rights, environmental protection, and sustainable development. The Human Rights Council stresses that the killings, human rights violations against and abuse of human rights defenders may violate international law and undermine sustainable development at local, national, and regional levels. Environmental human rights defenders' involvement in environmental decision-making, implementation, monitoring, and follow-up and review of the 2030 Agenda for Sustainable Development is crucial. For this reason, we must step up our actions and call upon United Nations agencies, national governments, non-governmental organizations, the private sector, and the general community to understand the vital role that environmental human rights defenders play in supporting states to realize the sustainable development goals. Ladies and gentlemen, today we are raising awareness, creating more visibility, and drawing more attention to environmental human rights defenders, specifically in the Asia-Pacific region, especially the most vulnerable defenders, indigenous peoples, ethnic and racial minorities, women. Defenders who have relatively little power, but also hold many of the solutions for good environmental governance and for sustaining peace with the earth for current and future generations. This working paper fills an important function by spotlighting key regional trends, as well as a range of positive paths and best practice models derived from experiences across the region and elsewhere. I am convinced that today's event and the working paper can contribute to a more comprehensive understanding about environmental rule of law and human rights in Asia Pacific, as well as spark further environmental and climate action and collaboration. Thanks again to everyone for joining and to ARIEL for facilitating. I wish you all a fruitful launch and an engaging discussion. Thank you.
Thank you very much, Patricia, for opening our launch webinar. It's an honor to have you. A lot of developments on environmental rule of law at the global level, and especially the need to defend our environmental defenders. So indeed, we're looking forward to hearing more about this issue in the context of Asia Pacific. So without further ado, let's start with the panel. We have our first panelist, Dr. Rowena Cantley-Smith. Rowena is an adjunct fellow at the Institute of Sustainable Futures and the Faculty of Law with the University of Technology in Sydney. She's also a barrister at the Victorian Bar. Her legal expertise encompasses public international law, climate change law, energy law, and environmental and human rights law, including energy justice and sustainable transitions. Rowena, thank you for being here, and over to you. Rowena? Rowena, you're on mute. Rowena?
I'm sorry,
Okay,
can you hear
great.
me now?
Yes, I can hear you now.
I apologise for
All
that.
good.
My cursor kept moving off the mute button every time I tried to click it off, so I do apologise.
Please
Thank
go
you.
ahead.
Thank you for that introduction. And thank you also to the Director of the Law Division of UNEP, Patricia. It was wonderful to hear your comments and to hear your support for this wonderful initiative. At the outset of this working paper, I'd like to acknowledge the Indigenous nations on which I'm currently located. And this is set out on my front slide here. I wish to pay my respects to elders past and present and future, and acknowledging that the traditional custodians of knowledge for these lands and waters. Okay, I'm sorry, Rocky, but my presentation doesn't.
We can see your presentation just fine, Rowena?
Yes, it won't actually.
Okay, we can share the screen.
Yeah, I beg your pardon, but it's just completely frozen at my end.
Okay. Can you see, if you share the screen, can you see it?
I can see it, but it won't move further forward. Now it is. I apologise for these technological hiccups.
No worries.
So today, my part of this presentation will cover the key findings for parts of this paper. So the key international developments, the common threats that are faced by environmental human rights defenders, and a brief overview of promoting the environmental law and some good practices that have emerged through that. My colleague, Professor Boer, will come back to this and then look at some recommendations. So the key findings in the first part of the paper on international developments can be put under these headings of the environmental rule of law, sustainable development goals, environmental rights, and environmental human rights defenders. So at the outset of this working paper, we acknowledge these linkages between humans and the environments, and it's noted on the one hand that the positive impacts of a healthy environment on the enjoyment of fundamental human rights is important, but on the other hand, the adverse consequences of poor environmental conditions on human life and well-being are also important to acknowledge. In this context, the working paper recognises the growing importance of the environmental rule of law. Environmental rights, such as the human right to a clean, healthy and sustainable environment, and also to the achievement of the Sustainable Development Goals.
Rowena, just checking if you can see the slides, just to be sure. Can you see it?
Oh, can you hear me? Would you like me to stop?
No, can you see the slides at your screen?
Oh, yeah, I'll try that again. It says it will stop screen sharing.
We have the slides on the screen, but can you just confirm if you can see it?
I can see that now, yes.
Okay, great.
Yes, okay. Oh, no, now I can see you, Rocky.
It's gone now. We're just fixing the slides. We'll put it back again very soon. But yes, please go ahead.
Yes, so when you put them up, if you can put them through to the second or the third or fourth slide, that would be good. I'm just conscious of time.
Okay.
So in the working paper, we use the United Nations definition of the environmental rule of law, which describes when laws are widely understood, respected and enforced, but also recognises the benefits of environmental protection when they're enjoyed by people on the planet. We see that the environmental rule of law is critical to the achievement of Sustainable Development Goals, particularly Sustainable Development Goal 16. Which seeks to promote peaceful and inclusive societies for sustainable development, to provide access to justice for all, and build effective, accountable and inclusive institutions at all levels. The working paper also focuses on the important role of environmental human rights defenders and the interdependent relationship between the environmental rule of law, environmental rights such as the right to a clean, healthy and sustainable environment, and the people who are seeking to protect the environment and environmental rights. The definition of environmental human rights defenders, as was announced in the opening here to this launch, is, according to the UN, any individual or groups who in their professional or private capacity and in peaceful manners seek and strive to protect and promote human rights relating to the environment. To this end, the working paper highlights the valuable and, importantly, the legitimate role of environmental human rights defenders. They have a valuable and legitimate role in implementing and achieving the environmental rule of law. They have a valuable and legitimate role in the realisation of Sustainable Development Goals, in particular, as mentioned already, the Sustainable Development Goal 16. The working paper also highlights the valuable and legitimate role of environmental human rights defenders to the enjoyment of environmental rights and the protection of environment. It's worth reflecting for a moment as to who can actually be an environmental human rights defender. And in short, it can be everyone and anyone. Environmental human rights defenders can be individuals, they can be groups, they can be Indigenous peoples and local communities. They can be international organisations, NGOs, government officials, public bodies, corporations, businesses. They can be lawyers, like many of us present. They can be judges, academics, journalists, and students. If we could just go to the next slide. So while everyone and anyone can be an environmental human rights defender, as identified in the working paper, human rights defenders, environmental human rights defenders, are primarily identified by what they do, not who they are. Essentially, environmental human rights defenders can be anyone and everyone who seeks to act in defence of environmental rights. In other words, everyone and anyone has the right to promote and protect a clean, healthy, and sustainable environment, which is necessary for the enjoyment of a vast range of human rights. Environmental human rights defenders play an important role in upholding and implementing and advancing the environmental rule of law and, in turn, sustainable development goals. Undoubtedly, the environmental rule of law and environmental rights, sustainable development goals are all vital to addressing the triple planetary crisis of climate change and the loss of biodiversity and pollution. But as articulated in this working paper, it's also critical that the environmental human rights defenders, those people who are engaging in peaceful actions to protect and promote environmental rights and the environment, are not only recognised for their valuable contributions to the environmental rule of law, to sustainable development goals, but also they ought to be provided greater protections for their peaceful work. In the middle part of this paper, the basis for finding that these greater protections for environmental human rights defenders is of paramount importance is evidenced by the rising number of abuses and threats that are being meted out against environmental human rights defenders and the escalating risks that they face. You could move to the next slide. You could just click. Yes, thank you. The UN Special Rapporteur has observed that the international community and states are empowered to protect environmental human rights defenders. But the common threats faced by environmental human rights defenders set out in this work paper suggests that obligations to protect environmental human rights defenders are frequently going unmet. There are a number of reasons for these, but despite their important, peaceful, legitimate work, environmental human rights defenders are being subjected to an alarming level of violent abuse and threats. As set out in this report, this includes killings, death threats, sexual violence, surveillance, land grabbing, judicial harassment, including slaps and criminalisation, and constraints or non-existent access to environmental justice. While time doesn't permit a deep dive into all of these common threats, it's worth drawing attention to the first of these, the shrinking or chilling of civic space. According to the UN, civic space is the environment that enables people and groups, or civic space actors, to participate in meaningful way in the political, economic, social and cultural lives of their societies. When we consider the key elements of civic space, participation, protection and promotion, we see that illustrated through the common threats faced by environmental human rights defenders that the shrinking of civic space often underpins or contributes to the general and specific threats they face. It's concerning, as set out in this report, to see that the shrinking of civic space is adversely impacting the achievement of the environmental rule of law. It's also adversely impacting the enjoyment of environmental rights, and of course, it's heightening the threats that are already facing environmental human rights defenders. The report draws examples from Asia-Pacific states that include reductions on constitutional guarantees concerning environmental human rights, the use of draconian cybersecurity laws that are used to restrict communications on the internet. These affect environmental human rights groups that are using the internet to convey peacefully information about environmental rights and matters that concern them. Other forms of the shrinking or chilling of civic space include restricting the possibilities for legitimate protest and other activities of civil organisations that are involved in environmental protection. Restricting public participation in environmental impact assessment processes is another way in which we see the shrinking of civic space. While all of these threats are indeed a terrible plight that are faced by the environmental human rights defenders, the prevalence of violent acts, in particular those that are against women and children, but also those that result in killings of environmental human rights defenders, are unfortunately on the rise. These have been catalogued by intergovernmental and civil society organisations for many years. Recently, the UN Special Rapporteur and other organisations have reported that when we review the number of killings of human rights defenders in the last 10 years, an average of 3 to 4 rights defenders has been killed each week. What's relevant to this paper and the threats faced by environmental human rights defenders is that more than 2/3 of those have been environmental human rights defenders. And this, according to all of these reports, is just the tip of the iceberg. Large-scale grabbing of land, often of traditional landowners, is also an important common threat that's being faced and evident throughout Asia Pacific. It's carried out by both domestic and international actors. It often can involve coercion. And also we see, again, with the chilling of civic space and constraints on access to environmental justice, these common threats are often interdependent. There's a lack of access to information, a lack of adequate public participation, and often an absence of free, prior and informed consent. Judicial harassment can take many forms, but for example, what we see in this report, evidence throughout Asia Pacific, that like many other parts of the world, the use of legal and judicial systems to silence and intimidate those who seek to criticise or oppose is also rising. Specifically, strategic lawsuits against public participation, known as SLAPs, are evident as a commonly used form of judicial harassment. They have a chilling effect on free expression, and they disrupt legitimate coercive action by civil societies. We see these growing in prevalence across Asia Pacific, and the trends also indicate that in addition to SLAP suits, there's also an increasing threat of criminalisation of the activities of human rights defenders, particularly when it's those involved in environmental matters. So the criminalisation of activities of environmental human rights defenders has increased over the past decade, and there's often coercive measures are being used, again, to restrict freedom of expression, right to protest, and access to justice. What's interesting about the constraints on access to justice, as drawn out in the report, is that while many Asia Pacific states have comprehensive and up-to-date environmental laws, it's the implementation and enforcement of these laws that remains a major issue. Sometimes that's identified as lack of political will. Other times there are reasons such as access rights, a right to information, and problems with decision-making that may be obstructed by complex bureaucracies or systematic issues. We could move on to the next set of slides. So just briefly, the third set of findings in this working paper turn on what we call good practices. So these are some good news. These are examples of where we can see states respecting the right of everyone to promote and protect a clean and healthy and sustainable environment, and in turn act to work towards achieving the environmental rule of law and sustainable development goals. The paper identifies a range of good practices, including bolstering human rights institutions at the national level, promoting regional human rights instruments or frameworks that are relevant to the environment, drafting national provisions on environmental human rights defenders and substantive and procedural environmental rights laws. One of the key good practices we've seen in some states in Asia Pacific is the drafting of anti-SLAP legislation or provisions such as the Supreme Court Rules of Procedure for Environmental Cases that's in place in the Philippines. My colleague Ben will talk about these more in detail, But just of note here, when we talk about the range of good practices that can be built upon across the Asia-Pacific region, it's important, as noted in the work paper, that the particular vulnerabilities of certain groups, such as women, environmental human rights defenders, are recognised, and that policymakers formulate gender-responsive and right-based environmental strategies, policies and practices and laws to ensure that women and girls can, like everybody else, achieve the enjoyment of the environmental rights, in particular the right to a clean, healthy and sustainable environment. Right, that takes me to the end. Thank you.
Thank you very much, Rowena, for that clear context of the EHRDs in the region, as well as the trends that are happening and good practices, of course, that we can adopt. It's been really eye-opening, especially the challenges that are escalating for EHRDs, which are doing peaceful work. This includes shrinking of civic space, harassment, and all those challenges. But now I'm looking at the chat box, Rowena, and I see a lot of people from all over Asia Pacific and even beyond. And I'm sure there are a lot of thoughts that can be shared, especially in our Q&A and discussion later. So we'd love to hear. You can please put your questions in the Q&A box. Please be reminded that your questions can be anonymous. So please feel free to share your thoughts and questions to our panelists later. All right, let's move to the next panelist. We have Leah Mai Torres. Leah has more than a decade of experience in community research, education, and organizing. She's been working on environmental rights and defense of environmental defenders for the past 7 years. Leah graduated with degrees in community development and environmental management at the University of the Philippines, and she's the current executive director of the Center for Environmental Concerns in the Philippines, and also part of the Secretariat of the Asia-Pacific Network of Environment Defenders. Leah, thank you, and you have the floor.
Thank you, Rocky. Let me just put my slide up there. So as Rocky mentioned, I will be discussing about the regional observations and reflections and the key findings of the paper. Before I start, I would just like to thank and congratulate the United Nations Environment Program for this very informative and helpful working paper. Okay, so I would just like to share first the observations or the trends discussed during the second Asia-Pacific Environmental Human Rights Defenders Forum that actually substantiate or validate the findings as presented by Rowena earlier. So in the forum, there were representatives from Northeast, Southeast Asia, and the Pacific. And one of the main trends was that civic spaces are shrinking in many countries across different regions. And environmental human rights defenders face various civil political human rights violations ranging from harassment, threats, intimidation, strategic lawsuits against public participation or SLAPs, or criminalization, vilification, arrests, and killings. And indigenous communities are often at the forefront of protecting the environment, making them more vulnerable again to the attacks of state and private security forces. And most of these attacks are related to projects such as mining, logging, and agribusiness plantations. So these so-called development projects are one of the leading causes of human rights violations. So these projects are said to bring development to local communities, but often cause more human rights violations, such as the displacement of families, loss of homes, and loss of livelihoods, as well as other security issues. So this drive for profit making is what we see that is driving the development aggression. And the environmental defenders, who are contributing very much to environmental protection, rehabilitation, and conservation, lack the support and protection such as through policies at the national level, and also through the lack of legal representation in the case of various human rights violations. So I would like to share 3 cases of examples of what I mentioned, the human rights violations and environmental defenders, linking them to their important contributions, the environmental issue in their community, human rights violations they experienced, and the impacts of the disturbance of their work in forwarding environmental rights. So the first case that I would like to share is the case of Chad Book. He is a teacher in indigenous schools of the Lumad indigenous people. So they set up community learning centers, harnessing indigenous traditional knowledge to sustainably manage their environment and also to forward environmental protection. So their community is facing the destruction of their forests and pollution, particularly in the province of Surigao del Sur, because of the encroachment of big mining companies. So because of their work, they have been red tagged, or the practice of the government of naming individuals and organizations as terrorists or as communists, thereby justification the justification of the attacks of the government state agents. So it got so worse that the name of their indigenous group, or the Lumad, was equated as terrorists, and they have been subjected to various types of harassments and threats. So in 2021, there was a case filed against him of kidnapping, illegal detention, and trafficking. And in 2022, he was killed by the military because he was allegedly part of the armed group in the Philippines. So the worsening attacks on the Lumad indigenous people has caused the loss of ancestral domains and livelihood of the Lumad indigenous people. All the schools that they set up were closed by the government, and the communities were forced to be evacuated because of the militarization. And the legitimate organizations in the communities essentially was stopped from operations because of the intense harassment and militarization. So the second case is in India, in the Diocha Pachani coal mine in Burbam district in West Bengal. So it could be the world's second largest coal mine and Asia's largest coal mine. And this threatens the forests and the ancestral lands of the Adivasis indigenous peoples, and possibly would cause the reliance to coal, and therefore hinder the meeting of commitments to phasing out of coal in India. So the local communities protested, and this resulted in the arrest of 9 activists in 2022. Women who were at the front lines of these protests were violently beaten, and the potential continuing of this operation would result in the relocation of 20,000 people and potential impacts to their livelihood, which are based mainly on agriculture. So the third case is the reopening of Solwara 1 deep sea mining project in Papua New Guinea, which is said to potentially cause noise pollution and other hazards because of the mining equipment and operations. The company, Nautilus Minerals, was granted a permit even without the free, prior, informed consent of the indigenous communities. So this threatens the very fragile ecosystems or marine ecosystems, particularly because of its operations in the seabeds. So why did I choose these cases? Because these are a reflection of the findings that was identified in the study, as well as the findings of defenders from the previous 2 Asia Pacific Environmental Human Rights Defender forums. So I would just want to highlight that when we talk about environmental human rights defenders, we hope that they won't be seen as mere numbers of people killed or number of people with human rights violations. These are actual people with very much tangible impacts in the environmental protection and in their communities. So we want them to be valued as very important individuals and not just as another case or another headline. So with that, we would also want to insist for the following recommendations to be pursued. So first is for the environmental rule of law to be improved in many countries in Asia and the Pacific because of the prevalence of the attacks as mentioned before. And the environmental human rights defenders are in urgent need of more concrete support from the state, civil society organizations, and international institutions. So we wanted to highlight that there are many gaps in terms of support for defenders, and these are often filled by civil society organizations and other institutions. And there should be more coordinated efforts to have a programmatic effort to support defenders. And we'd also like for the continuing countering of the vilification of businesses and states of environmental human rights defenders by highlighting their important work or achievements in their communities and in their countries. And also, particularly attention should be given to groups that are most affected, such as indigenous people and women. And lastly, it is very important to address the root of the attacks, which is the environmental plunder and destruction. And under the current climate crisis, it is more pressing that we urgently take action. So that's why I wanted to highlight the importance of this publication to emphasize the relation of the environmental rule of law, sustainable development, as well as the important and life-threatening attacks and defenders that also causes life-threatening impacts on people who depend on these natural resources. So again, thank you and congratulations to UNEP and ARIEL and the organizers of this event, and hope that this publication would encourage more action from everyone. Thank you.
Great. Thank you very much, Leah, for that presentation and giving us concrete case studies and your reflections as the Secretariat of the Asia Pacific Network of Environment Defenders, which is at the forefront of protecting the environment across the region. So we've tackled 3 case studies from a range of countries: the Philippines, India, and Papua New Guinea. Cases in the face of development projects for different environmental issues, from the land to the oceans, affecting environmental defenders as well as indigenous peoples. An important thing I think you said, Leah, is that it's important to remember that these are actual people with tangible impacts in the communities, right? And we don't want them to be just a statistic. So that's why we have to escalate the need to defend these environmental defenders. And of course, the last point that you made, that addressing environmental destruction is key. So this is the root of all the attacks. So we have to actually address environmental issues and the impacts that these projects have. Now, thank you very much again, Leah, for that. And now we are at our third panelist. Our last panelist is Professor Ben Boer. Ben is an emeritus professor in the University of Sydney Law School. He specializes in Asian and Pacific environmental law, international environmental law, and heritage law. Ben has been teaching and researching in this field since the 1980s. These days, Ben works mainly at the intersection between human rights and environmental law. And so, Ben, thank you very much for joining, and over to you.
Thank you very much, Rocky, and lovely to see everybody online. I wanted to thank my previous panelists, firstly Patricia Maboti, and then Rowena, of course, with whom I've been working very closely on this working paper, and then Leah Torres and your wonderful presentation. I wanted to say particularly that without the work of civil society organizations, the work of UNEP and the Office of Human Rights Commissioner simply can't be done. And APNED is at the forefront of this work across the Asia-Pacific region, as well as we've seen, in other parts of Asia. So I wanted to commend that work and also encourage other civil society organizations to be involved in this important space. So what I'm going to do now is to look at the recommendations that have been made, taking on board some of Leah's important points in the final slide, and to try to just tease out what these recommendations are and to explain them a little bit more. So just one moment. So you'll have heard already about the good practices that Rowena put forward in relation to the environmental rule of law and the issues relating to environmental human rights defenders. I'm going to recanvass some of these in a very brief way, looking at the international, regional, national, and sub-national issues with respect to both policy and legal reforms that we would suggest are required in order to promote the environmental rule of law on the one hand, and to particularly look at the issues and mechanisms arising from the activities of environmental human rights defenders. So you'll see that with the material that is in front of you, there are a range of issues that are set out. These are also reflected at great length in the paper itself in terms of what the good practices are, but I wanted to look particularly at some of the issues arising out of some of them. One of the first points that I wanted to make is that the role of national human rights institutions has become far more important in recent years. But unfortunately, as the working paper itself says, national human rights institutions in the Asia-Pacific region are very varied in terms of their approaches, in terms of the support that they get from their national governments and the scope of their activity. So some do it well, but generally speaking, they could improve very greatly. So the national human rights institutions do need a good deal more regional support, is what I would want to say. When we look, though, at the promotion of regional rights instruments relevant to the environment, this is something that the working paper talks about at length. When we look at the Aarhus Convention and the Escazú Convention, we're now very much more familiar with what their mechanisms are in terms of what we call access rights in the environmental space. But what we also are looking at and seeing is that in the last decade or so, there's been a great deal of discussion across the Asia-Pacific concerning the development of a framework or set of agreements relating to the question of the right to environment itself. We see the Human Rights Declaration under Section 28 of ASEAN, recognizing that human right. But the question now is whether or not there should be, from every area, from, let's say, South Asia, from Southeast Asia, from the Northeast Asian region and in the Pacific region, should we be looking at more activity in this space in terms of getting regional agreements on the right to environment and all that implies? We should note that in the last couple of years, ASEAN has put together a group of people in order to start discussing in a very serious way the development of an environmental rights framework, and the Asian Intergovernmental Commission on Human Rights is behind this, together with, of course, UNEP and other organizations. So the work that is being done in the regional human rights space is something that is very important, but it needs to be encouraged much more by national governments. When we're talking about the particular work that has been done in some countries, focusing especially on environmental human rights defenders, we see that for the last several years at least, there has been a human rights defenders protection bill in the Philippines, and that has been widely discussed. It has been through various processes within the legislature in the Philippines, but it still hasn't been enacted. But on the other hand, we see, and the working paper refers to this, we see that the Legal Status of Human Rights Defenders Act was passed back in 2021 in Mongolia. Our suggestion would be that many other countries across the Asia Pacific could look at the experience within our own region, and in analyzing those pieces of legislation and their provisions, saying, well, how could these be enacted in our own countries in order to focus particularly on environmental human rights defenders and, of course, human rights defenders more generally. You'll also see in this slide a particular focus on procedural laws, what we often call access rights, procedural rights that will guarantee or at least promote the implementation of substantive laws. One of the things that we need to focus on here is this question of free, prior, and informed consent, or FPIC. It seems to us that this is a fundamental aspect of procedural law, but it also has substantive aspects here, which we also need to understand. The connections between the procedural and the substantive aspects are sometimes rather difficult to sort out. But this question of free, prior, and informed consent, which is best illustrated, for example, in the whole process of environmental impact assessment, needs a great deal more focus at a national level in order to ensure that both minorities as well as local communities, as well as the community in general, takes advantage of this particular concept of consent, which is free, prior, and informed. Of course, the issue of drafting substantive environmental laws is yet another issue. And we see right across the region, from West Asia through the Southeast Asian region, right over to the Pacific, we see a great deal of inconsistency in terms of the way in which environmental laws themselves have been drafted, what their standards are, and so forth, let alone the question of implementation. The working paper also talks about the drafting of judicial rules of procedure for environmental cases, and we note that some countries, such as the Philippines and Thailand, have, through their Supreme Courts, put together a set of rules in order for their judges to follow them in terms of ensuring that environmental cases are dealt with in a particular way, and focusing in particular on the issue of strategic litigation against public participation, or SLAPs, as my colleague Rowena has talked about this afternoon. So this question of drafting anti-SLAP provisions is very important, and you've got a reference there to the Philippine Supreme Court rules that have been around since 2010. Indonesia and Thailand, as I've noted there, also have drafted rules in order to address some of these issues. Let us now look at the international recommendations that have been put forward in this working paper. We see this divided into four: access to protection mechanisms, dissemination of information, the question of capacity building, which is central to what we are doing here with this working paper and with the subsequent the educational capacity building programs that are being contemplated. And this is where we see UNEP and the Office of the Human Rights Commissioner working together to actually put capacity building programs out there, particularly working with other bodies as well, such as the Asian Development Bank and the IUCN, the International Union for Conservation of Nature. But the issue of awareness raising is particularly important, and this is where UN country teams across the Asia Pacific probably need to coordinate much more closely in order to ensure that awareness is raised of the environmental rule of law and its importance, and then in particular looking at the situation of environmental human rights defenders, thinking through what the goals of the Sustainable Development Goals are, what the implementation of the SDGs really means, and in particular the 169 associated targets, with this idea, as Patricia mentioned, of leaving no one behind. The reality is, of course, that people are being left behind, as various of the reports continue to say. At a regional level, I've already touched upon some of this, but we can simply urge that there needs to be a coordinated approach to the protection of environmental human rights defenders. At the moment, there is virtually no coordination at all in relation to what happens, for example, with the various cases that Leah has put forward, and we need to see that there needs to be a lot more consistency and coordination happening there. It seems to me also that we need to negotiate regional frameworks for EHRD protection, and as part of a broader set of issues relating to the development of regional agreements on the right to environment itself and its protection, as well as the protection of EHRDs. And I've also already mentioned this idea of SLAPs, but one of the things that the working paper puts forward is to develop best practice model laws for anti-SLAP, so that countries can come along and say, well, look, this is what we need to do, and we can actually focus on some of those issues. So then, in terms of what should happen at a national level, we see that the whole range of recommendations that have been put forward, and in particular, looking at UNEP's Environmental Human Rights Defenders Policy Brief, which was first drafted back in 2017, still highly relevant, still not well enough known, and not well enough implemented. The question of gender mainstreaming, which several speakers have talked about, or aspects of that, also needs to be looked at in terms of the disproportionate threats faced by women, by youth, and by children. And then, as I've mentioned, we need to think much more seriously about the role of free, prior, and informed consent when we're thinking about Indigenous people and ethnic minorities, and in particular, looking at the recognition of Indigenous peoples and ethnic minorities in constitutions or in national legislation. And then finally, where such provisions do not exist as yet, the paper recommends that the right to a clean, healthy, and clean, healthy, and sustainable environment ought to be incorporated at constitutional level, as well as within the national laws of a particular country. When we look at the Asia Pacific region in particular, we see that only 4 or 5 have got satisfactory constitutional provisions relating to the right to a healthy environment. And then the other 3 recommendations that we see there, the anti-SLAP provisions that I've mentioned, the anti-criminalization measures are also detailed in the working paper. I've mentioned FPIC laws, and I've mentioned specific environmental human rights defenders laws, well. So that in very brief compass is what the working paper recommendations are about. For those of you who have not yet downloaded the paper, I recommend that you do so, that all of us need to be very much aware of what these issues are and what can be done from a policy and from a legal point of view. So finally, while I have the floor, Rocky, I'd just like to acknowledge also the ongoing commitment of our leader, Dr. Georgina Lloyd, in this important endeavour to bolster the environmental rule of law and to strengthen the legal and policy mechanisms to address the issues of EHRDs across the Asia Pacific. And we would want to thank her for the unwavering support that she's given to all of us, and to thank her on behalf both of the presenters as well as the participants here. But we're also very glad to have the support at the highest levels of UNEP, and in particular from Professor Kameri Mbote. So thank you, Rocky. I'll look forward to the discussion.
Thank you very much, Ben, for that fantastic presentation, and yes, for acknowledging all the work that everyone has been doing on protecting our environment and our environmental defenders. So it's very important what Ben's presented as the important recommendations drawn from good practices to promote the environmental rule of law and protect EHRDs. But he also noted some tidbits that might be interested to a lot of participants here, like how human rights instruments are being used in the environment space. You have a lot of developments at the global level, both as to substantive rights, what we've said, a clean, sustainable, healthy environment, and also procedural environmental rights at the global level, but now also cascading down to at the regional level, especially here, closer to home. And we also have, aside from regional and global developments, a lot of national initiatives as well on legal reforms and developments on environmental defense, on EHRDs across Asia Pacific. So thank you for those exciting recommendations and a lot of things that have been happening, updates on what's been happening in the region. And at this point, first, I'd like to thank the panelists for all their fantastic presentations. We are now opening the floor for the questions. If I could just invite the three panelists back again, Ben, Leah, and Rowena, to open your cameras as we open the floor to a lot of questions. I'm looking at the Q&A box, and there have been a lot of questions and a lot of interest on what you have presented. So let me start with the first one, which is more on the practical and grassroots side of campaigning and what EHRDs are doing. So in a lot of countries across Asia Pacific, there are some cases that EHRDs get massive and intensive public support through digital means. So the question is, how does digitalization be optimally utilized in the campaigns for environmental protection? Maybe I'll ask Leah first for her thoughts on this.
Yeah, I think maximizing digital spaces to really highlight the work of environmental defenders have grown more important, especially during the pandemic, when we were not allowed to go out. We utilize the whatever space that we can have. So this can be through social media, and for some organizations through their websites. And there are also organizations now that are supporting defenders to improve their capacity in using these digital spaces, particularly in ensuring the security in releasing information. So I guess it is still something that we can develop and work towards maximizing.
Great. Thanks, Leah. Ben and Rowena. I think I'll go to what's happening at the national level, because that's very important in this discussion. And there are a lot of questions and queries at the ways to strengthen national reforms. And so this question at the national level, what are the important or the recommended provisions in legislation for the protection of EHRDs, like any specific provisions in EHRD legislation that could be adopted? That's the first level. And the second one is there's a question also about the role of courts, and have there been any instances where courts were instrumental or have been instrumental in enforcing environmental rights? So I'll put those two questions, maybe first to Ben and Rowena at the national level.
Okay. Do you want to go first, Ben, or would I?
I'll just address, thank you, I will address the role of courts. We see that in some countries, the courts have been very proactive in terms of developing the Supreme Court rules in order to address particular issues, in particular slaps. And I think that, as we mentioned on the slides, 3 or 4 countries that have done this. Other countries, in other countries, the judges are not perhaps as forthright or as, let's say, courageous as in other countries, and perhaps they should be looking at what their sisters and brothers doing on the benches there. But in particular, there's really a question of the judiciaries across the Asia-Pacific region understanding what the problems are. And that's why capacity building is so important. And this is where the Office of the Human Rights Commissioner, UNEP, the Asian Development Bank, IUCN, and other international bodies, as well as the regional bodies, such as APNED, should be involved on a continuing basis. There are new judges coming on all the time. We need to really ensure that the judges are very much aware of the problems and how they can be solved, and the issues to do with FPIC and slaps and so forth are some of the issues that really need to be at the forefront.
Right, great point on the role of courts, really, and the need to capacitate more the judiciary. Rowena, over to you.
Yes, look, I'll just add a few things to what Ben said, and I think it's really building on that and the need for judicial and legal capacity to be built. I think what we see with courts is that they have an enormous capacity to be a force for good and protect environmental and human rights defenders, but of course they're also, unfortunately, open to misuse. And we see that with things like slaps and the criminalisation of certain actions of environmental and human rights defenders, and of course other rights defenders. I think it's interesting when you link that back to the comment before about the digitalisation strategies, that on the one hand, the internet can be fantastic, but it also has a double-edged sword that we see, and there's some of these things articulated in the report. We see that things like doxing and red tagging, the internet gets used for reputational damage for certain environmental and human rights defenders, but also we see that defamation cases have also been on the rise in terms of environmental and human rights defenders, journalists, academics, others, NGOs, etc., who published information on blogs, etc., that have actually fallen foul of the judicial system and the legal system. So I think, again, it comes back to greater education and capacity building and institutionalising the important role of environmental and human rights defenders and the need to protect them, and also coming back to the point that what they do in international law is recognised as legitimate,
right,
as long as it's peaceful.
Yes, good point. And in relation to the remedies, because we're talking about the courts as having remedies for grievances of EHRDs, for example, like in relation to this, what would you say, like recommended or exemplary provisions in national laws, either here in Asia Pacific or elsewhere, that can be adopted so that we can have more recourse to the courts, for example?
So if I could just step in, Ben, and I might just quickly look at the issue of slaps, which addresses, I mean, criminalisation of defamation is also a slap in the sense that certain behaviour has been criminalised. And the classic one is when we see criminal defamation instead of civil defamation. So that itself, we could see that provision, there's already been quite a lot of discussion on that, of changing those provisions in the countries that they exist. In terms of looking outside, I think that one thing that we're being cautious about in the report is that there are a lot of examples in other places that can be drawn on, but it's also important to recognise the local situation. And while, for instance, if we wanted to look at some of the most recent discussion on SLAPs, we would look at the Europeans directive that was put into place last year, still awaiting approval, but they've written a very extensive direction on the protection of environmental and other rights defenders against SLAPs. The UK is doing likewise. America and Canada have extensive years and years. I mean, the whole term SLAP originated in the US. So, but there again, there's many states in America that have laws. There are some that don't. So again, there are lots of things we can look at, but I think some of the ones that are closer to home in terms of the Philippines, for example, are really important. And I think there are other laws that are being, my understanding, I think Georgie has something to say. Sorry, Georgie, to call on you. But I think in one of our discussions recently, you mentioned that some other Asia Pacific states are looking into drafting their own relevant SLAP laws.
Right, thanks. And lots of good practices that can be drawn from here, both in the region and beyond. Any thoughts, Ben? And Leah, also on the Philippine Environment Defense Bill. You can also talk about that a bit. Ben first.
Oh,
you're on mute, Ben.
Let's hear from Leah first.
Okay, Leah.
Thanks, Ben. We have developed the Environmental Defense Bill and filed it in December 2020. It is our effort to have a national sort of version of the ESCAZO agreement and access to public participation, information, and justice. So we have developed this through a series of consultations and different organizations all over the Philippines. And it is also similar to the Human Rights Defenders Bill that is also passed in Congress. It has been more advanced in terms of the stages and the legislation, but I think both bills, though a positive step, would be facing challenges, especially in the Philippines, where human rights policies rarely make it to the final reading. So I guess it is important to have developed these policy, but equally important is the public pressure from environmental defenders themselves, as well as supporting organizations and institutions to make sure that policymakers will really approve these policies and for the president to sign this.
Right. And that's the reality. We have all these exemplary provisions in those bills, but the challenge really is to how to enact them, or like making sure that they're enacted. And that comes from public pressure as well. No? And Ben, some thoughts?
I was going to just build on that in terms of what may be needed in terms of a regional approach. In the working paper and in other work that we've done, we've been looking at the appointment of a special rapporteur under the Aarhus Convention, Dr. Michael Firth, who has been given